Ripple XRP, settlement in February. 14,000 financial institutions are ready. XRP news today. I hope that previously you have heard about the SEC lawsuit filed against XRP. But do you know that recently the two have reached a solution that not only would prevent a blow to the goodwill of Ripple, but would also protect the company from any harm? Curious? Want to know about what decisive stage they have reached? Then stay with us till the end of the video and find the answer to your questions yourself. So let's get straight to the video. Now, that question is at the heart of the closely watched US Securities and Exchange Commission lawsuit accusing Ripple and two top executives of conducting an unregistered offering of $1.3 billion in XRP between 2013 and 2020. And the lawsuit, which the Securities and Exchange Commission filed in the waning days of the Trump administration, faces several hurdles in the coming months. Additionally, a Manhattan federal judge has been asked to decide, for instance, whether a regulator should have clearly disclosed the digital assets it supervises rather than using enforcement actions to rein in the industry. So, Ripple raised almost $1.4 billion through the sale of XRP in violation of the SEC's investor protection rules, while its co-founding and chief executive, who they also sued, made hundreds of millions of dollars from trading. Also, the company says that XRP is used only for making international payments and it isn't an investment to be overseen by the SEC. However, before the SEC first announced in 2017 that its regulation was meant to protect investors from misleading hype and fraud, XRP transactions occurred. As a result, regulators have said only a few digital assets, such as Bitcoin, are commodities exempt from federal regulation. According to the SEC, the money transmitter sold the digital coins, which gave the appearance that XRP was in greater demand. In either event, Catherine Dowling, general counsel at Bitwise Asset Management, which manages several funds that hold cryptocurrencies, said, "We will have an outcome that will inform how others act and what decisions they make." And Ripple, whose defense attorneys include former SEC Chair Mary Jo White, has litigated aggressively. Furthermore, early in the case, it sought records from the SEC that might have shown whether the regulator had allowed its staff members to trade XRP. A judge denied the request. It also sought emails from within the SEC that might show regulators to be uncertain or divided over which tokens fall under their oversight. Although a federal magistrate judge ruled in January that Ripple and its executives could request some records from the SEC, the agency was allowed to keep much of its thinking secrets. But there is also a contradiction to it, as Ripple claims that the SEC has been cagey about which crypto assets it regulates, support its argument that it lacked fair notice about XRP's status. This lawsuit might not go to trial until next year, which has attracted much attention since many crypto companies argue that regulators should update regulations for digital assets rather than rely on lawsuits to enforce regulations written in the 1930s. Moreover, Ripple and Larsen, Torres said, both urged her to review the memos in full in weighing their arguments to dispose of the case. So according to the judge, there is no doubt that the memos are judicial documents and are therefore presumed public. But if you think this is the end of it, then you might have to change your thoughts. Further, the SEC has asked a judge to block the fair notice defense, saying the company had warnings about XRP's status as a security. Ripple got US legal advice as early as 2012 that XRP could be deemed an investment that would require SEC oversight, according to the agency's court complaint. However, Ripple chief executive Brad Garlinghouse earned almost $160 million from 2017 to 2020 selling XRP, which he received from the company. And Christian Larsen, who was the company's CEO until 2016, earned $450 million from the sale of XRP from 2015 to 2020. Based on the SEC's calculations, his wife, Sarah Larsen, earned $10 million from the sale of XRP during this period. But with great luck and fortune, Martin Flumenbaum, an attorney at Paul Weiss, Rifkind, Wharton and Garrison LLP, who represents Mr. Larsen, said, "We believe the record is clear that XRP is not a security and that SEC does not have jurisdiction over this matter." So Ripple's duel with the SEC has influenced its agenda in Washington, with the firm lobbying Congress to consider a bigger role for other federal agencies such as the Commodity Futures Trading Commission. And over the past year, the company spent almost $1.1 million lobbying, including supporting legislation that would give crypto companies the option of choosing CFTC supervision. The SEC has argued in court papers that Ripple's lobbying efforts fueled any confusion about XRP that might have existed. Furthermore, according to Stu Alderotti, Ripple's general counsel trying to squeeze digital assets, which are more akin to commodities than securities, into a securities regulatory framework simply doesn't work. all roads don't lead to the SEC because the SEC doesn't have a rational regulatory framework. Interestingly, as the SEC noted in its brief urging the judge to unseal the 2012 memos, Ripple and Larsen did not press arguments in their seal motions that the memos are privileged. The memos, in other words, are sure to be key evidence in a case that is widely considered to be a critical test of the SEC's ability to regulate cryptocurrency offerings through enforcement actions. The SEC has also said the public needs to see the memos, at the very least, so the Commission can show that it has not mischaracterized the documents. The Commission told Torres that the memos provide important support for its motion to strike Ripple's affirmative defense that the SEC failed to provide fair notice. And now, thanks to a ruling last week from U.S. District Judge Annalisa Torres of Manhattan, we don't have to rely on either side's description of the advice Ripple received from its outside counsel in those 2012 memos. Torres held that legal advice in the two memos must be unsealed and released publicly by February 17th. So after all those controversies, the two have solved settlements because the case never got into a state of trial. If this case got some more exposure and achieved a higher level, it could have gone worse for XRP. But fortunately, it was settled without any fistfights. Therefore, for the consequences, if the trial would have proceeded, then the result would have been entirely different. In other words, if SEC won the trial, then XRPs and all tokens would have been sued and the company would have had to pay a hefty fine, which would be devastating. On the other hand, if Ripple had won this case, SEC would have withdrawn its lawsuit, and moreover, a fine would be imposed on XRP by making the tokens digitized and traded through the SEC. Also, the SEC would have to pay some ransom for the damage done to the company's name and reputation. Either way, it would have resulted in damage and devastation for both parties if either would have won. So, for the betterment of both, they chose to settle the matter and come to an agreement that at the present, 14,000 financial institutions, which is quite a large number, would be ready to trade XRP tokens, and on a small scale, since neither Ripple's innocence nor its unregistered way of raising capital can be proved yet, this number is probably going to shoot up pretty fast, don't you think? So in my opinion, if everything goes positively according to what we expect, then the SEC will have to withdraw its lawsuit due to lack of enough evidence and the settlement will be fair and square. Depending on the situation, it may also come that Ripple will get more exposure in the market due to the attention it is getting on a global scale amidst the case going on right now. Now that we have come to an end of this video, let us thank you all for staying with us till the end. Don't forget to tell us in the comments section what are your views regarding the Ripple and SEC lawsuit, and what do you think? What will be the final result of this settlement? Will it end in the favor of XRP, or will it result in Ripple's loss? If you have found the video interesting, go ahead and hit the like button, and if you are new here, subscribe and click the bell icon. This way you will be notified of all the future videos from us, including upcoming XRP news. We'll see you in the next one. Until then, peace.